So I'm pleased to introduce you to one of my partners in our private client team, Sophie Davis, who has many years' experience in probate, inheritance tax, trust law, and of course the creation of lasting powers of attorney. And it's in that respect that she's talking this morning in relation to business lasting powers of attorney, with the topic and the question being, can your business survive the loss of a key individual? So over to you, Sophie. Thank you.
Thank you, Davina. Good morning, everybody. Thank you for taking the time to join us this week, particularly as it's quite a sort of difficult week in light of the announcement at the weekend. I know that many people have got things to line up or make sure running smoothly. So thanks for taking the time this morning. I hope it will be helpful and actually quite topical to considering the world's current circumstances as well, is making sure that we can all function in the light of uncertain events and unexpected areas. So this is the first time I've done a online webinar, so do forgive me for my technical abilities. I'm just going to share my screen, so just bear with me for a moment whilst I do that, and then we'll get going on that. So hopefully you can all see that, just a title page on that. So as Davina mentioned this morning, we're discussing about whether your business can survive the loss of a key individual. And we're exploring the impact of loss of capacity or death on a business owner, whatever the size or structure. So it really doesn't matter what size business is, if yourself or your clients, if anybody in the ownership of that were to lose capacity or pass away, there is a very real impact for all businesses at all levels. And I'm just going to, talk about why that's relevant for a minute, and how many of us spend time preparing our work for when we go on holiday, making sure there's holiday notes, handover provisions, and sometimes we're sat at our desk thinking that actually there's more work to go on holiday, and why do we bother? And thinking about that concept, then why would we not apply the same to thinking about what would happen if we were unable unexpectedly to be able to carry out our function, or one of our colleagues or business owners was. So it's about thinking about those eventualities, which obviously we hope won't occur during our working lifetimes, but actually we're looking at longer life expectancies, as this slide shows. People are retiring at a higher age, state pension keeps increasing, so some people are delaying retirement until that. Many people just aren't ready to retire, at an earlier age. It depends which side of the coin that you fall on that. And also then, in a personal element, is that we're seeing that there are increasing disputes in estates and involving the call to protection, where someone has lost capacity. And that therefore means that there's a high likelihood that your business or a share of it will get caught up in some of those. And particularly that part of the cause of that is that there is more diverse family structures. So I was going to do something nice and technical with pictures, but actually if you were sat in front of me now as my client, I would really just draw you stick men in lopsided houses. So I've gone for the same approach here. And our little red-faced person down there is very angry at the others, and sort of exposes that actually you can have one person within a set that can, their circumstances can create difficulty, or others can be unhappy about them. And just thinking about how it's relevant, oddly what I found during my time practicing is more people seem more able to think about their death than to visualise them losing capacity. But it is a growing issue, and here's some statistics taken from the Alzheimer's Research UK, and their website's very interesting, lots of statistics on there. But you can see that 1 million people in the UK will have dementia by 2025, and increase to 2 million by 2050. So that's as a result of that research. What's really relevant for us in a business world, and thinking obviously we're all looking forward to a retirement at some point, but it's a common misconception that dementia is a condition of older age, and over 42,000 people under 65 years of age have dementia in the UK. And then in the bottom left-hand corner, we can see some statistics that 1 in 14 over the age of 65 have a risk of developing dementia, and that increases, quite substantially as you carry on and get older, and 1 in 6 by the time you're over the age of 80. And so that's a really clear indication that we really need to be thinking about this as businesses. And the legal world has really come on in being able to accommodate this. When lasting powers of attorney were introduced, the legal world has been looking at the development of business powers of attorney and gradually learning how we can use those to really accommodate that. So just looking very basically at the structure of some businesses, on there we got, and I'm going to talk to you sort of about these 3 main categories. Obviously there's some divergence beyond that, but these are the 3 main categories that we see. One would be a sole trader. There's no real governance, no law legislating the sole trader in terms of what happens if they pass away or lose capacity. The sole trader is their business, so it falls under the same rules as they have personally, in that it's part of their assets or part of their estate. Looking at a partnership, we got, first of all, we looked to see if there's a partnership agreement. If there's no partnership agreement or it doesn't cover the position, then the Partnership Act, sorry, there's just a typo there, of 1890 applies, not 1980, 1890 applies. And company is, we look at the Articles of Association or looking at any shareholders agreement. So just going to take you through each of those individually and set out some key points in either what would happen on incapacity or on death. And looking at sole traders, we say they are responsible for their business and the day-to-day functioning of the business. Many of the business powers lie with them, including paying bills, payroll, business purchases. Even if that authority has been delegated, if a sole trader is lost capacity or passes away, that delegation doesn't necessarily continue. And if I start just on the right-hand side on death, as you'll see, employment of employees terminates on the death of a sole trader. So yeah, any authority delegated to an employee to deal with certain matters essentially terminates. Business assets form part of the estate and so are dealt with under the will or intestacy. And the business may naturally conclude on the death of a sole trader. So certainly if I was have my own business which really just involved me giving advice, if I passed away, then that would cease quite naturally. But there is always final bits to be dealt with, some of which can be done under the estate. But if there is a wish for someone to be able to just run the business for a period of time to wind it down in an appropriate way for that circumstance, then we really do need express powers in the will to do that. And those express powers can include appointing a manager to be able to oversee that, and dealing with employees and really anything that may just allow the business to continue as long as is relevant or necessary or wished, really. If a sole trader loses capacity, the business is obviously still there, it's not gone anywhere, but there is nobody to deal with the overall management and the employees and those duties that we've talked about. So essentially the business is sort of suspended in the same way as the personal affairs of that individual are suspended. So the business in many ways may well be able to not be able to operate until someone with the authority required to step in, either an attorney under a power of attorney, or otherwise it would be a deputy at the Court of Protection. Court of Protection timescales, as Georgia and I are very familiar with, are very long. The process is very laborious, and it's certainly not a position that we'd want to see anybody in personally if possible, and certainly not in relation to a business. And that can, as it says there, significant detriment potentially to business employees and their families, suppliers and the family of the sole trader, particularly if that sole trader is the person bringing in that main income to a household, and that business cannot operate in the way that it should, then that can have a greater impact as well. Looking at the partnership, as we say, partnerships are governed by the Partnership Act 1890. There's no partnership agreement, or the Partnership agreement doesn't cover an issue, then the provisions of that Act apply. So looking at that on incapacity, it's not specifically mentioned as loss of capacity in the Partnership Act, but it does provide that if a partner becomes permanently unable to perform their part of the partnership contract, a continuing partner can apply to the court for the partnership to be dissolved. Obviously, that's not an ideal situation for you to be in as a partner, or your clients to be in with a partner having to take that action. And then a couple of things within that is that not all incapacity is permanent. So you can have a temporary situation, which is often arises more as a result of an accident or temporary illness. It can cause upset and ill feeling between partners and their families. So if somebody's saying, well, we need to apply for this to be dissolved, or we need to deal with that, and others aren't in agreement, it's a very sensitive area, and there's a lot of emotion involved at that time on a personal level. So that can be very difficult. As I mentioned there, court delays as well, in that you are going to be subject to the court timescales. Continuing partners are open to risk, either in terms of the business itself and the suspension of that in terms of what the partner who hasn't got capacity can do, and also in terms of proceedings against them if it's felt that they are making that application to the court and there may be any discrimination involved or something of that nature. It's not possible for partners to simply expel another partner. So if you say, well, we'll just chuck them out at that point, it can't be done, and you'd be at risk of proceedings following as a result of that. If a partner dies, technically the partnership is dissolved and all assets must be realised and liabilities paid. And that's something that we often see in practical terms. A lot of partnerships where a partner has died, is actually the partnership just seems to have carried on, and it's not unusual. I've seen one recently where actually there's several events that would have terminated the partnership during the course of it, and yet it doesn't seem to have been flagged. And there is a practical position where the partnership in some ways does continue, so it sort of naturally continues, but actually legally, if someone was to be disputing the position, and as we've seen with increased litigation and increased concern in this area of disputes, it's likely to become more open to challenge. So the best thing to do is to have a partnership agreement that covers that, and so that we don't have that automatic dissolving. And then there's also the financial element of what we consider that. So taken from the HM Revenue and Customs website on the second point under the death section is, if no arrangements or agreements have been made, the estate of the deceased person is entitled to the share of the profits made since death that are attributable to the use of their share of the partnership assets, or to interest at 5% per annum on their share until their share of the partnership is paid out. That's quite substantial, particularly for a partner who is no longer there to be able to deal with the winding down or move forward. So again, it's better to look at the position and put the partnership in the control rather than leaving it to the decision of the personal representatives necessarily. So moving on to a company, companies can be slightly more complex. There can often be more people involved. People often get companies sort of off the shelf, and there is more complex provisions around delegation of that powers. But looking firstly at what happens in terms of if there was a shareholder or key individual, would be the articles of the company is what we look for, and or any shareholder agreement. On incapacity, if there isn't anything like that, then we're looking older articles that have not been amended and refer to the role of a director upon incapacity ceasing automatically can be deemed discriminatory. So by saying actually, well, you've lost capacity, you can't act anymore, and so you're no longer a director, can be seen to not accommodating the needs of someone with a disability. And as I say, it's not often as simple as that. Capacity is not necessarily a black and white issue, and is not necessarily a permanent state either. Since that discrimination element has been raised by the courts. Articles after the 28th of April 2013, standard articles no longer provide that a mentally incapacitated director would cease to be a director, but you've still then got the problem that we've got a director there who cannot exercise their functions. So it doesn't solve the problem in that respect. And it can have a significant impact on the business who need to fill the skills-based and day-to-day workload that the director can no longer carry out, albeit temporarily or permanently. If a shareholder were to pass away and there's no specific provision in the articles or shareholder agreement, the shares form part of the estate of the deceased and are dealt with under their will or intestacy. And this can mean that if I was a shareholder in a company and I held 50% of the holding and I passed away and I was in business with you, then my shares would pass to whoever I've chosen to leave them to. So, for example, if I've left them to Davina, then all of a sudden you've got someone involved in the company who you don't really know necessarily and may not have the business acumen or understanding, or may have competing interests which affect the decisions that they make. There's also quite often disagreements about valuations that we see on a practical level, and actually all of these things we can deal with within shareholder agreements or in wills. And quite often we see people come in to make wills who have shares, and we talk to them about what provisions that there may already be in place, because what's in place in a partnership agreement for a partnership or a shareholder agreement for or articles indeed for a company would take precedence over anything in the will. And in terms of the wills, quite often it's a case that, oh yeah, it's something we've been meaning to do, we can't quite get everybody on board to do it, and so we talk about creating provisions in their wills that suit them, not necessarily that those would suit the company, but and it's not far off in many respects the sort of options that can be covered in shareholder agreements, but the benefit of the shareholder agreement is that the agreement reached in there, of course, is binding on everybody, and it's been agreed, and the overall finances of putting that all in place have been set out and considered as well. So there is very real merit to you doing that in agreement. You wouldn't let one of your colleagues go off and make something which would affect your business ordinarily. So why would we, you or your clients, allow that to happen with the shares on death? So I've just done a little summary, just because they are slightly more tricky with companies, is that just a summary that for companies that have adopted model articles after the 28th of April 2013, or have otherwise removed the model article that causes the potential discrimination issue, as you will see that some people have, a mentally incapacitated director will not automatically cease to be a director, but the issue of what should then happen does need to be addressed. And the directors may amend their articles of association to include a delegation authority by an individual director if the articles don't already permit it. It's really important that if we're looking at LPAs in this sense, that the articles don't block that being used. And the delegation is often of voting rights or other actions that the individual can carry out, as opposed to being able to fully act in the role of director. I won't go into the full details of agency law at this point that can apply here, but that for those of you who know, the role of a director cannot be delegated. So you cannot do a power of attorney that simply puts someone in your place as a director, but you can delegate some of your rights and authorities that would therefore protect your position. So actions for directors and shareholders would be to check the articles of association, make sure there's appropriate delegation authority in there, and if not, then you may wish to amend the articles by special resolution. Check to make sure that there's nothing in the articles which could be considered discriminatory under the Mental Health Discrimination Act of 2013, and again it would be a special resolution to amend that if necessary. Consider whether all directors should make a business lasting power of attorney to protect the company's interests, and making sure that there's LPAs and shareholders agreements in place, and that your wills are reviewed so that everything follows suit. So looking at those circumstances and what can happen if there isn't a power of attorney or a will, it really does highlight the need for these to be put in place. And ideally, where we're talking about businesses with more than one owner or person with input, is looking at some sort of open conversation about that. In some ways, there's no real magic to the business powers of attorney. So you'll see there, it's much like making a personal property and finances lasting power of attorney, for those of you who are familiar with those. It is in fact exactly the same form, and there's no specific distinction, and that is up to the careful drafting within the document to make sure which lasting power of attorney applies to someone's personal elements and someone for their property. And the reason for considering making those separate powers of attorney is that my husband, for example, I would very much be happy for him to deal with my business and my personal finances. He knows the ins and outs of those, but actually I don't think he'd thank me very much for having to deal with any business decisions or making decisions of that nature. And I don't think any colleagues who suddenly had him on board would be thankful for that either. So certainly there is scope for the separate powers of attorney, and also because of the competing interests. So my personal interests may very much compete and be in conflict with potentially business interests, and so sometimes splitting off those so that everybody can action their functions in the way that's appropriate for the best interests of that situation is required. And so each power of attorney must have a clearly defined scope. If you've already got, or your clients have already got, a lasting power of attorney for property and finances and are interested in putting in place the business lasting power of attorney, it's important to make sure that there's no conflict between which one applies to which area. As I've mentioned, it's important to ensure that all relevant documents are reviewed and amended as necessary. So I could see a client to put in place a business lasting power of attorney, and I could draft it as beautifully and put everything in. But if the governing documents of that organisation or that business don't allow that to be operative or have different provisions applying, then I would have done that work really in vain. So that's why it's really important for those to be checked. And often we sort of hear, well, surely it's quite straightforward. But as I say, my bit in terms of the drafting, it can be, but we need to be making sure that the bigger picture is addressed and that we consider the business as a whole. And also something which Georgia and I are both favour quite heavily is making sure that the restrictions or guidance or in the lasting powers of attorney are used and tailored for that individual. And I think that that's more important, even more so with a business power of attorney, and particularly where there's say partners who have both said, yeah, we need to put these in place, and they have sort of agreed parameters that potentially can be included in the partnership agreement or in the shareholder agreement for a company, but there's still place for the lasting power of attorney to be able to create that function for someone to deal with that interim period. And so looking at it as a whole and making sure it overlaps and that the relevant information is drafted into the business powers of attorney helps make it clear for everybody involved as to what the scope of that is designed to be, and helping, sometimes the powers of attorney will simply be that, yes, capacity is lost, this situation cannot continue, and we now need to work on an exit strategy for that incapacitated partner or shareholder or director, but we've then got someone in place under the power of attorney to be able to represent that person's interests in that respect. And then just looking at wills. So as I've already said, anything provided for in a partnership or shareholders agreement will take precedence over the will. So again, it's important that we check what's in there and that what we're advising and what we're incorporating follows suit and everything works together as a whole. For sole traders, it's really important that if they do want there to be sort of a run-off period or for their business to be able to continue, that powers are included to allow the personal representatives, the executors, to be able to run the business. Essentially, so that, as I've already mentioned, could be appointing a manager to deal with something. So if you've got sort of a small independent shop, negotiating end of lease, those sorts of things. And you can appoint separate executors for the business. So again, we talked about that before, why that might be desirable between personal finances and in terms of business finances, and the same may well apply to wills. So you can split off and have separate executors for that. Partnerships should have a partnership agreement in place to avoid the complications that can arise from the automatic provisions of the Partnership Act applying. So as I've said, essentially that is dissolution of the partnership on death. That's rarely what's intended. And as I say, that moving forward, I no doubt that there will be more and more contentious cases where businesses or partnerships are involved in an estate, and the partnership, the actual provisions of the Partnership Act will be reviewed and implemented, and that may stop this sort of natural carrying on. So it's really not worth taking the risk for anybody involved, and having that partnership agreement in place is really important in that respect. Companies without a shareholders agreement or other arrangements must be prepared for shares to pass to those outside of the company. If they haven't got those agreements in place, and be subject to the provisions contained in that individual's will as to how the shares pass. And when we're drafting wills and there isn't a shareholders agreement, and we're looking at that, is we often set out a basis for how those shares will be calculated and the value of that. We can give options for the company to purchase those shares, but all of that really is best enshrined within a shareholders agreement, which our corporate and commercial teams we work very closely with and can help review everything as a whole. But yeah, as a company, you could potentially be held to the terms of the will, and if you haven't thought about that and the finances alongside that to be able to buy out that individual share, then that's something that really requires some careful thought. And there are various options to be built into wills, powers of attorney, shareholders agreements, partnership agreements, which can save a company or business considerable time and money by planning in advance as opposed to waiting until the situation arises. And as I sort of said at the beginning, is you wouldn't go on holiday without leaving some indication as to what's going on, I'm quite sure. You wouldn't make a business decision without doing the research and making sure that everything was in place and correctly actioned, and we should be treating the death or incapacity of a business owner in the same way, because there is a real risk of that happening to someone in relation to their business or who are involved in that, and that's not something that we would ever choose to be in one of these positions if that occurred. And it's really sort of thinking about the time and expense and the issues that would arise as a result of that if we don't put the provisions in place now. And this is something that's sort of grown over time. Certainly the introduction for incapacity of lasting powers of attorney has given much greater scope and opened the door to separate business powers of attorney far more than enduring powers of attorney ever did. And we should really embrace the ability to be able to have these options available to us, and really be able to plan and structure businesses in a way to accommodate for all eventualities, to avoid considerable issues and upset and distress for all of those involved. And that is the end of the slides on that. So hopefully it's given a useful summary for you in terms of the overall position. Obviously there's a lot of intricacies that can sit within that, but hopefully it really does give a clear sort of starting point for you and your clients as to what can be done, why it's so important that it should be done, and that we at Scown can really provide that as a whole for you and your clients. In that there's myself and the private client team. We've got a fantastic disputes and resolution team, as you can see from Savina and Georgia here. We all work very closely together. and we've got our fantastic company and corporate and commercial teams who can help us. You know, I don't profess to be an expert in partnership agreements or shareholders agreements. I know what I need to know for the purposes of my area, but obviously the ins and outs of those, that's what our colleagues in those departments specialise in. So Stephen Scown, we can certainly provide you with that place where you come to us for us to look at it, or direct your clients for us to look at it, and we can provide that and that review for you without having to sort of work between solicitors going, that solicitor said this and this solicitor said that. You know, it's very much an in-house service in that respect, and would be only more than delighted to provide any information or advice that you or your clients may need at any time. So that's it for me. I'll just hand back to Davina.
Thank you, Sophie. That was really interesting, and I don't know whether any of our guests have any specific questions for you. If so, please do make yourselves known, or perhaps send a message on the chat function. Whilst we wait for any specific questions, I thought maybe this is an opportunity to involve Georgia as well, and to ask both of you. When we're dealing with normal, personal lasting powers of attorney, particularly for property and financial affairs, there's an opportunity for people to object if they don't agree to the choice of attorney. And I wondered if either of you have had any experience of that in the business LPA context, or whether you have any other experiences to share.
So I don't personally have any experience of objections to that, largely because when we're looking at putting them in place, is we sort of try and so when the drafting process is, we try and iron that sort of territory beforehand, and that's why it's so important for businesses and partners and companies to really discuss that between themselves, and have sort of an open conversation about it. Certainly we've had the dialogue over the course of the really sad and unfortunate events of this year of let's talk about it in terms of mental health and death, and the same applies here in terms of the management of things in the event of capacity. So certainly my role in that respect is to try and preempt anything within the drafting, and to make sure that everything is as smooth as possible. Certainly if we were then to have an objection, it's something I would tend to then work with Georgia. So perhaps Georgia, if I pass to you.
Yeah, I likewise, I haven't got any experience in terms of business LPAs having objections raised against them, but certainly I've got lots of experience in terms of people objecting to choices of attorney in personal financial situations, and the process is identical. So it's it just depends on what the issues are. Unfortunately, when there is an objection, then it can potentially end up in court proceedings, and like Sophie said, the idea is to make sure that the documents are drafted properly, and the reality is that attorneys need to be involved in the process of drafting the attorneys, as they need to sign the documents because they need to know what they're signing up to in the first place, and therefore you would hope that, provided everybody is talking about it, that there won't be objections. Objections tend to be raised, in my experience, in personal circumstances where family members just simply don't talk about the position, and that is going to be the same situation for businesses as well. So my advice really is to make sure that you talk about mental incapacity and the eventuality of that, but you also talk about death and things like that as well, because in my experience of contested wills, it's the same thing. It's often because people haven't had that conversation.
Thank you. Do we have any questions from our guests, or has anything come up, Georgia, in the chat?
No, there's nothing in the chat. So no, but please feel free. I think Sophie will put our contact details up. So if you, I think it's the third slide down. But if you do have any, or second slide down maybe, but if you do have any queries, then please do get in touch with us, and we'd be more than happy to help.
Thank you, Georgia. Well, unless anybody has any further questions, I think that I'll probably propose that we finish this webinar, but I'd just like to thank everyone for joining us, and to reiterate what Georgia said about, please do contact us or our corporate commercial colleagues if you have any questions in this area. Thank you.